Hi, my name is Robert Chelle with Chelle Law, and my firm assists physicians with employment contract issues. Today I'm going to talk about what is a non-compete in a physician contract. Of all of the things in a contract, this is, besides compensation, this is probably the area that I discuss the most with the physicians I'm, reviewing their contracts. It can have enormous ramifications on a professional's career, depending upon a number of factors, which we'll get into. So let's just do some basics as far as non-competes go. So in most physician contracts, there will be restrictive covenants. And so restrictive covenants are basically things that the physician can't do when the employment contract ends. So standard restrictive covenants would be a non-disparagement clause. So you can't kind of badmouth the employer in some way. Non-Solicitation Clause. So you would be prohibited from actively soliciting patients, employees, other physicians, independent contractors, business vendors from the employer. And then there also would be a non-compete. And so the non-compete essentially prohibits the physician from working within a specialty for a period of time in a certain geographic area. So let's kind of get into the details of that. So first, in every contract, there will be, in the non-compete, there will be a section that kind of details what the physician can't do, meaning, let's just say it's a internal medicine physician who's working as a hospitalist. So the non-compete would state that the physician can't work as a hospitalist for the period of time within the specific area. Now, one thing to consider here is if you are in a specialty where you can do different things, so let's just take the internal medicine physician as an example. They could do primary care, they could do urgent care, they could do ED, they could be a hospitalist. If in the non-compete, it says you can't practice medicine, within that area, well, that can have, pose some problems if the physician needs to be in that area. So you want to make certain that it specifically states in your specialty for the employer. So if you're a hospitalist, it needs just to say the physician can't work as a hospitalist within that area, within that time, not the practice of medicine. For many physicians who can do multiple things, an easy way around the non-compete, although maybe not, a perfect scenario, but they could, for a year, do something else, and then after that year, come back and then work, within their desired specialty. So that's the first thing. What does it actually entail? Is it the complete practice of medicine, or is it just in your specialty? Should be just in your specialty. So next, how long is the non-compete? Well, most non-competes are a year. Many employers will stretch it out to 2 years. Anything above 2 years, I don't think would be enforceable anywhere. If you are a physician, you do not want a non-compete longer than 1 year. It's just an equitable amount of time. I think, no, this is state specific, right? So I'm kind of giving you a broad outline of this. I can't go through all of the states in this video, but speaking generally, most courts have held that 1 year is about the limit that they would consider a reasonable non-compete length. So if you have a non-compete, you want to limit it to at least 1 year, nothing beyond that. And then the geographic restriction, this is probably the most important one. So once again, generally anywhere between 5 to 15 miles would be considered a reasonable non-compete. Now, in some states, they'll push it. For whatever reason, the Midwest states seem to really push it to more than that. So 20 miles is not uncommon. You also have to think about where you are located. 20 miles in a rural location that completely knocks you out of a city is certainly a lot different than 20 miles in a big metropolitan area, which can knock out, many potential opportunities. So, maybe you're a cardiologist in a small town in a smaller state, and it says 20 miles from your office. Well, there may not be another office that you could even, get into within those 20 miles. So that doesn't really matter. Let's say you're in Phoenix, where I am, and 20 miles here could knock out hundreds, thousands of jobs potentially. So you would like to limit it to as small a geographic restriction as possible. I've seen so many variations. It could be by county. In the South, they seem to use counties more than just, a mileage. Normally it's as the crow flies. So if it says you can't practice within your specialty for 1 year, within 10 miles of the office, it's not kind of a Google Map road 10 miles. It is as the crow flies. So stick a pin in it, 10 miles all the way around. That's how it's calculated. For many people, a non-compete might be the most important thing in a contract, and for others, it might not matter at all. So for physicians who are in a city that they don't really have any ties to, they're just there for the job, they don't care if they're there after the fact, then we would spend kind of more capital in getting different things changed in the agreement. So maybe the compensation or providing tail insurance or something like that. But if you are a physician who is either moving to an area to be near family, or maybe you have a family yourself and you just don't want to pull your kids out of school and move them across country, well, then the non-compete could be the absolute most important thing. So if you're with a private physician practice, I find there's much more leeway in negotiating the non-compete. Many of the larger hospitals, healthcare networks, they may just say, take it or leave it. We're not going to negotiate. I also find that some of those big hospitals change their non-competes frequently. We have a huge healthcare network where I live, and I think every year it vacillates between different mileage and then whether you can join a private practice and that's exempted. Just kind of goes back and forth. So you certainly do have leverage in getting that changed in some instances, but honestly, I wish I had a better answer for you, but in some instances, it's going to be a take it or leave it offer. So you need to think about, all right, what's most important to me? And then you always have to get to the point where, once again, if you have to stay in a community, you won't have any options to practice there under the terms of the non-compete. Then you just have to figure out a way to move on. Some jobs are simply not worth it. And if you accept a job, you're accepting the non-compete. They are enforceable in nearly every state. There's only a few states where it's not enforceable. So when you sign that agreement, you need to understand that that non-compete is likely going to be enforced if necessary, and whatever terms you agree to are the terms that are going to hold. Last thing, if you are negotiating a non-compete, maybe you can offer some concessions in other areas. So for instance, like with the non-solicit, it may say you cannot attempt to solicit patients, employees, whatever. Well, you could say, for instance, I'll agree not to hire, not just solicit. I will not hire any employees, any other physicians, independent contractors. And that way you're less of a threat. If you're in kind of maybe like a primary care-ish type specialty, you're going to open up a new office. The biggest concern of any employer is they bring a physician in, they leave, they take all the patients, all the employees, and that old employer is kind of stuck. So maybe giving somewhere else might be worth the employer agreeing to, kind of amend the non-compete in some way. So those are the basics of a physician non-compete. I hope that was helpful. If you have any questions, you can always call my office at the phone number listed below in the description, or you can reach us through our website, chellelaw.com, CHELLE law.com. Again, my name is Rob Chelle, and I appreciate you watching the video. Thanks.